Tom Grajek, get Greyjack. That's your tagline. I love that tagline. Injury, criminal defense lawyer, Lakeland, Florida, and Tampa, Florida. And look, Tom, some of the most creative, brilliant, entertaining, and educational social media I've seen. There's a video you've done where I loved where you drank a beer and you went off screen with the beer. And you did a whole check afterwards to see if it actually would hold up in court of whether or not your blood alcohol content is able to be held. You have so much good stuff. I'm so happy to have you on.
I appreciate it. I love you. You're one of my favorite people that I get every time I go to a seminar. I'm like, is Mike going to be there? I just love seeing you and talking about all the law, the legal stuff. And did you watch part 2 with the rum cake?
I did not. I have to see that.
One of our chiropractors brought over the rum cake, so I was going to eat it and see, does rum cake make you drunk? And I started eating the rum cake, and I don't want to eat it. And so Sam, our paralegal, came in, and she ate it and blew a .018 off of rum cake.
Oh, yeah. My gosh.
So, yeah, educating.
People definitely have to check out your stuff. Yeah. That's literally...
I hate to talk. I'm like really excited about this topic and speaking with you about it. So,
yeah, I mean, look, we have a lot of great conversations back and forth, and one of the more salacious ones that I've been excited about is the 15-year battle, this war with talcum powder, $4.4 billion verdict. You have so many great ideas and different insights coming from a criminal defense background, a personal injury background. Just you're an outsider looking in. What's going on in this crazy lawsuit in your mind right now?
So, Mark Lanier, who just won the internet addiction trial in Los Angeles, was the attorney who got the $4.4 billion. I mean, that's insane. It's got to be one of the biggest verdicts ever, right, Mike?
Definitely up there. It's certainly up there.
And it got reduced on appeal down to $2.2 billion. And the way I got introduced to Mark was I saw the $4.4 billion, and I'm like, was anybody show up on the other side, right? Because you see a lot of the ego verdicts. Ego verdicts are getting really big.
Sure.
That'll be another podcast for us, right? And so I'm like, who's this Lanier guy? And how do you get $4.4 billion? And so I signed up for his seminar, and that was Lanier 3.0. And after going to Lanier 3.0, which that's where I met you, was at Lanier, I don't know which one it was, 7, or I've been to every one since, and I'm going in June, so I can't wait to see you there.
Yeah, Trial Academy.
Yeah, Lanier Trial Academy in June. Best thing ever. If you're a trial attorney, you're not going. If you're a defense attorney, that's for dang sure. And so I go to the seminar, and you're watching Mark, and you're like, dang, never knew that. I mean, he is incredible. One of, if not the best lawyer I have ever seen or learned anything from. Just incredible. And he's also an incredible person. And I saw some people get upset because the Wall Street Journal article said, oh, he's a part-time preacher. He was going to go to theological school. He was going to become a preacher, but he still does it every Saturday. And the money we pay to go to a seminar, I think it's up to $1,500, and it's worth every penny. He donates all that to Guatemala, if I said that right, I know it's a difficult name. He donates all the tuition to his charity. He doesn't take a dime off of his seminar. But he got the $4.4 billion, and after listening to him speak, and he did the closing argument, told us exactly what he argued in that trial, I was blown away, and I'm like, I'll give you $4.4 billion. It was that good. It was incredible. Have you heard it?
Yeah, I was just about to ask you because it was so brilliant, and I'm trying to recall the swamp and different things. Do you remember anything about that or how it went?
So when I should have reviewed it before, just busy because I had trials this week, and none went. And so... So Mark's big on roadmaps. So what a roadmap is where are you taking the jury? What is the case, like a table of contents? So you know where the story's going. You know how long a witness is going to be on the stand, what they're going to talk about. And so he did a roadmap for the closing argument, which you're driving down the highway of life when all of a sudden, bam, Johnson & Johnson hits you and knocks you into the swamp because they hit you with their talcum powder, they cause cancer, and you end up in the swamp of cancer. And he went through every devastating thing that someone who suffered cancer goes through. The treatment, the fears, who's going to look after my kids? I'm going to miss the graduation. I got to go to cancer treatment. It just was unbelievable and so powerful. It was incredible. But I think just when he did it at the seminar, I think it took over an hour, and I think it was longer in the trial. But it was powerful and incredible. And you go, that's why you got that's why he's good and why he's got $4.4 billion.
Yeah, it's captivating. And he really has a mastery over psychology of communication. And it's understanding how to distill down very complex ideas. You're brilliant at it too, actually, when it comes to so many complex ideas and things. And you're able to distill it down into common speech so that anyone can understand different concepts. And it's a talent that trial lawyers have, and it's a talent that a lot of storytellers have that is just fascinating and it's captivating. That's why he's a great pastor as well. You know, he's a speaker, he's an orator, and he's just someone that you can just listen to forever. He should do those books on tape where you can listen to it and you know, you just listen forever. I actually was going to shift gears and be controversial for a second. We were talking about Beasley Allan and Allan Smith. And
which
so
is huge and crazy.
Yeah, it adds this chaos, right? Like disorder in the court. I don't know if we want to call that this conversation, but when you're looking at, you know, your unique perspective again, you know, coming from these different areas, spending your career very much in the defense side and on the criminal defense
side,
you know, criminal defense side,
Don't
right?
put me in insurance defense.
Yeah,
right?
You're the good guys. You're with the good guys.
Yeah.
You specifically chose, as far as I remember, you chose not to be a prosecutor in your career, and
Right,
that was
starting out in criminal. Yeah, you know, I'm there to help people.
That's right. That's right. So what made someone like you, right? You have this diverse background, criminal defense trial lawyer, personal injury lawyer. You're paying attention to the Allan Smith and Beasley Allan situation. Like, what about this fight is fascinating to you?
The reason for everybody, it's the money. The money is crazy. You know how, this is the way I described it. We have Mass Torts Made Perfect seminar, which is another great seminar. And I went to that and people came back, and it was the second time I was exposed to Mass Torts, because I was there with Roger Dodds and another attorney running it out of Washington, Friedman. Rick Friedman is another really good lawyer. And then I went to Mass Torts and someone said, what's it like? And have you ever heard the stories where people go and get stuck with someone trying to sell you a timeshare?
Every time I travel, especially on the cruise ships.
They just trap you and they don't let you go. That's a Mass Tort lawyer. These Mass Tort guys want you to refer them cases because the money is incredible. I mean, the money and that's why we're on this Allan Beasley, Beasley Allan, or what's it, Beasley?
Beasley Allan, Allan Smith. Smith Law Group.
Because they got the two names. And I wanted, in order to understand this part of the craziness and what is just, to me, the wow factor, is you have to understand kind of where it started with Mark winning that $4.4 billion. Mark originally did not want to take the Talc cases. He did not think there was an out in it. You have to understand that as lawyers, that when you take a case on, there has to be money at the end. We're businessmen like anybody else. And so when someone comes in and they say, hey, I want to hire you for my car accident case, and the other person does not have insurance, they do not have a job, then the lawyer's not going to do anything or not take your case because there's no money in the end. So the lawyer's going to go get a huge ego judgment, go, all right, we got you $10 million, but you're never going to see a dime of it. And the lawyer has to invest time, money, because he has to do depositions, he has to file the lawsuit, he has to serve it. But if the end there's no money to collect, you need a big pocket to collect from, or any. And if there isn't one there, the lawyer doesn't take the case. So originally, Mark did not want to take the Talc case. He saw no exit strategy. That changed. I don't know the exact reason. I think I know, and it's kind of key to these cases what changed his mind. And from there, I think that really set things off into crazy land and how we're going to get into Allan Smith's story. And I hate, because again, this is Lanier. You go in primacy, recency, and keep the viewer engaged, but you have to understand this part of it. I think this part's very exciting and interesting, but you have to understand this part to understand the super legal circus that's going on, which that's my plug for my podcast. So, but that's kind of where going from can you make money to everybody seeing dollar signs.
That's right. The financial viability of the lawsuit. I mean, you have that's the genesis of the conversation that Johnson & Johnson had with their Texas two-step, right? I mean, that was
right.
that was their fear, right? They saw this financial vulnerability. We said viability. They almost have a vulnerability, right? What's my exposure? You have all these investors now saying, "Excuse me, this is a problem. How much are we possibly going to lose?" You have the fear of Johnson & Johnson's stock just plummeting, right. All these pressures compounding over and over. And so they did what we affectionately call as the Texas two-step with LTL management. And then so when you're talking about like how that played into the decision-making of getting into this, when you talk about the science of everything, I love that you have the ACS forensic lawyer scientist designation, right? And by the way, only 1 in 4 lawyers in all of Florida have it. So crazy good scientific background. I know you're going to be humble about it for a moment, but I think it's really important.
I am.
You want to say something?
You got to have the background, and you got to have the time to put in. To do that, we had to take a test. It had to be certified through the American Chemical Society. But you had to go we went to Chicago 4 times, trained in the lab, and I think it was like $25,000 to just in the expense of going, hotels, travel, to put in to make yourself a better lawyer. But that's what you've got to do so that you have the background to understand when your real expert comes in to know what they're talking about and how to question them in a courtroom.
Yeah. And so I wanted to get your perspective on this, right? We talked about the 15-year war of science almost, whether talc causes ovarian cancer, the women who used it, actually the men as well for mesothelioma and those kind of conversations. But the crux of most of the individuals are ovarian cancer, right? And so Johnson & Johnson's entire strategy is surrounded by making that science look uncertain, fuzzy math, not really real. Right. And so they're implanting into the jury that this isn't right. And from someone with your understanding, and your background in forensic science and how it can be used against defendants, how do you think Johnson & Johnson has really played the science argument, and where does it kind of fall apart?
The problem is, when I went and first heard this, I'm like, what? Talc causes cancer? Like, you're blaming Johnson & Johnson, and I think everybody watching this is like, wait, yeah, how's Johnson & Johnson talc cause cancer? What's going on? And how do you know it's not coming from some other contamination, some carcinogen? Everybody's saying this causes cancer, that causes cancer. So before my first Mark Lanier seminar, I'm like, I don't get it. Even with what I know about science and everything, I don't get it. And I think that's what Johnson & Johnson was banking on, is jury ain't going to get it either. Now, did you know what it was before either Mark or somebody started explaining it to you?
No, until Jim Onder went on the road and started, taking his story and trying to recruit people, and Allan Smith and everybody trying to recruit people into this. I didn't actually know what was in talcum powder, and it wasn't until they started discussing asbestos that it started having legs, at least for me as well.
And so how are you involved in those? Or
we do the case origination, the marketing for acquisition. Fancy terms for we connect people who have gotten hurt to lawyers who can help them, right? And so a lot of our conversations are raising awareness and going out there and going on the internet, going grassroots in town halls, and raising awareness so that individuals know there's a lawsuit out there. I mean, a lot of times, many of these lawsuits, you only have about 8% of the actual people who had an adverse event who were hurt. In this case, women who developed ovarian cancer even know to file a claim because they have the
It's
same
huge.
preconceived notion you do. Yeah.
It's huge because go really and no, and so you're out there educating them, going, no, you do this, you're not responsible. Someone else caused you this pain.
Yeah. And we have to hold them accountable.
Right. That's what this isn't winning the lottery. These people who suffered and got the 4.4 million, the 21 plaintiffs, that they give it away if they could. I guarantee you, they to not have to go and suffer from the cancer, they would. And so, yeah, what you do is extremely important because people do not know. I get people all the time. We had a huge case, I can't say because it's confidential, walking out of my office and the secretary says, oh, she's crying. I'm going to go, what's wrong? And she goes, my sister was riding her bike. The cement was raised, hit the bike, flipped over, and said now she's got brain damage. And we say, oh, you got a lawsuit. And she goes, no, that's her fault. She did it. And I'm like, no, somebody didn't do their job properly. Somebody didn't put up warning signs. And that ended up being a case. I see her nephew at the gym, and he just comes up saying all the time, thank you so much for helping us out, because that verdict takes care of her now for the rest of her life because she still needs care. You have a 40-year-old woman wearing a helmet on her head because she needs protection due to that injury because somebody did not do their job and she was severely injured. And that's what makes it worthwhile when you do that for people. But I'll tell you what, she'd rather have her full faculties back and be able to not have someone taking care of her, not wearing a helmet on her head in a heartbeat. Money can only do so much.
Yeah, I think that's the part of the education piece of, you talk about class actions versus mass tort. You talk about, a bank error in your favor and everyone gets $2 from Bank of America or Chase Bank or whomever might have been. And they think of it that way and they go, oh, well, the lawyers are just trying to make a buck. Now, the lawyers do have to make money. You are a lawyer. You have to make a career. You have to be able to provide for yourself. But it's really putting systems in place that cause change. And what I mean by that is you have people, communities, entire groups of individuals are put at risk. And these companies will put profits over individuals every single time so they can make as much money as possible. And they only will hesitate if they think they're going to get sued, and to what degree do they get sued. It's your job to hit them in the pockets so that they make change. They think twice before taking advantage of somebody. And what happens is, in this situation with talcum powder, asbestos was used or was included, and there was an acceptable amount of asbestos that was allowed in, and that was the conversation.
Well, let me stop you there because that's what sort of a misconception, at least my understanding. So that I got the flag. The greatest country in the world. I love that we're a capital society. And the goal for the companies is to make as much money as possible for your stockholders. And so that's where profits over safety comes in a lot of times. And so that's what a greedy lawyer serves many purposes, but you have to make money in order to fund these cases. That's what really, we didn't even get to the crazy part of this podcast. Yeah. But this is all important to understand why it got so crazy and why it's nuts out there. So the reason I interrupted you was when you mine the talc, this is from learning from the case in the seminar, when you mine talc, it contains asbestos in it. You cannot separate asbestos from baby powder. And because of these lawsuits, that's why you cannot buy baby powder. You can go get cornstarch, but you cannot get, it's taken off the shelves, the talcum powder. And so the problem was, as you got back to it, is when you mine it, the asbestos is in there and there's nothing you can do to get rid of it. And then the whole question and the science of it is, well, how do we know this cancer caused it? And do you know how they prove this cancer caused it? What? Yeah. This is it. This is the big thing. Johnson & Johnson's own scientist, one of the ones they hired, said your talcum powder causes cancer. It was their own doctor that they said, one of their researchers, because they've had multiple, and they always had to come back saying, this does not cause cancer. And there was the one who stood up and said, I did the study, and baby powder, talcum powder, causes cancer. Now, what was the big problem with that witness? She did not want to testify. She did not want to get involved. She was in Germany. And so Johnson & Johnson, the allegations are they did numerous, and they came, look at it. We did this test. We did this test. We did this test. And it shows does not cause cancer. Not enough, not enough, not enough, over and over again. And the way this one scientist said, no, it does. And so you were asking, how did Mark win the trial? What's the science behind it? Mm-hmm. And the problem was that every scientist that Johnson & Johnson used did not use the right scale. That was the problem. And the scientist in Germany, the researcher, used the correct scale. And Mark, again, visual mastermind, storyteller mastermind, did it by trying to find a needle in the haystack. Or if you were going to take a needle, I should have had one. Again, hopefully Mark doesn't see this and go, why weren't you prepared and had the needle to show people? And if you put it on your bathroom scale, what is that scale going to read?
0.
But if you take that needle and you put it on, let's say there's, you're making these needles for we just had the space launch, right? You needed a needle for the space launch, and it had to be exactly 0.0002 grams. What are you going to use to weigh it?
One of those exceptionally sensitive scales. I forgot they're called, atomic scales, something like that, right?
Exactly. And that's what Johnson & Johnson do. Study after study after study use the wrong scale, and yet finally we had someone use the correct scale, and they emailed Johnson & Johnson, I believe, and said, hey, this causes it, because they finally used the right scale. And that's how Mark explained it to a jury is, you know, if you have to weigh a needle and you put it on a bathroom scale, you're going to get 0, and you go, see, not enough, can't cause it. But when you use the right scale, then it tells you. And then you get into they didn't really make money on talcum powder, but it was how they got you into the brand of trusting Johnson & Johnson and using all their other products, so that this was a bell cow for Johnson & Johnson. Because the way marketers work is that you want someone who's not really made their decision yet on what product they're going to buy, what for the rest of their life. Because once you get past 25, you're like, I'm not changing my deodorant unless they don't make it anymore. You use the same deodorant over and over and over again. That's why radio stations, TV stations, Super Bowl, because they have the target market that advertisers want, people making decisions. And so that's what talcum powder was, and why the allegation was they hid it, or, you know. And so this scientist did not want to testify, but finally did. And I think that might have been the reason why Mark changed from, I don't want to do the talc cases, not sure you can win them. There wasn't the evidence there, until they found this scientist in this study, and it was emailed, I believe, to Johnson & Johnson, and there you go. There's your smoking gun.
It's amazing. And then you have the conversations of, you know, how it was culturally incorporated into society, in the American society. You know, if I use it because my mother used it and because my grandmother used it, right? And it was the old school, raise your right hand. I essentially use it every day. I don't feel clean without using my Johnson & Johnson baby powder. So this was regular use and regular exposure. And as you were saying, Tom, if there's even a little bit of asbestos over time of regular exposure, you start seeing the science of how that exposure over a long period of time could potentially cause some sort of cancer, especially if it's an ovarian cancer or mesothelioma.
Or, as the jury said, did cause cancer. Not potentially, did. To the tune of $4.4 billion. Which, that gets us to I think we're getting to the crazy part. And
we had a whole lot of money involved.
It's the money. Like, you're going, if you're a lawyer doing, DUIs for $10,000, and that's even on the high end for some people, Tiger Woods going to pay a little bit more than that. But you're going, I'd heard, I don't know, because I'd have to, I know there's calculations in it, but I heard the attorney's fees were $850 million, but I don't know, that's kind of a guess. But you want to work for $10,000 or you want to work for $850 million? What kind of lawyer do you want to be? And not anybody can just go in and go, oh, I'm going to do an asbestos case, where we're getting to on this too. But you need the background to understand how crazy is getting the money. And so that's why this is going to get crazy. And I want to talk about one more thing before we get into. So Mark is in criminal court. When you try a case and you get a hung jury, the percentage and chances of winning a second trial are extremely low, and they're difficult. Do you know why that is, Mike?
I actually don't.
Okay. I thought you might know. You figure out because you're smart. It's because the prosecutor knows what your defense is now. They know everything you're going to argue, all your questions. It's like they did a mock trial, a focus group, and so they go back and they go, let's change our theory, our presentation, or block off this defense so it will not work. And so, or, maybe you had a juror on there that, you're like, let's make sure this type of juror does not get on the second jury. So they get a practice run so much, it's really hard to win after a mistrial. It happens, but it's difficult. So after Mark won his trial, what the defense does, because Johnson & Johnson got a lot of money, and they got smart lawyers too. They're not dummies either on the defense side. I think Mark's better, but they will then go, wait a second, and this is big. In the next trial in San Francisco, they did a motion in limine, and they prevented the plaintiff in that Talc case from using Mark's swamp closing argument. That is huge. So
they called it irrelevant?
Yeah, on relevancy. Yeah. So they came into the judge and said, Judge Stanisi, that this swamp argument is so outrageous, it's not relevant, and it's so prejudicial. Do not allow the plaintiff's attorney to make that argument. And the judge sided with the defense and did not let him use Mark's argument. So that goes to your criminal case. They go, we learned. We're going to cut you off at the knees, or try to cut you off as much as we can. And I don't know. We're going to have to research it again. And I don't know. We put in a lot of time. We've been reading a lot of articles, and it gets confusing because we get some conflicting stories from the articles, because you got each side saying, this is my side of it. And we did a lot of research for this podcast. But I don't know what the verdict is. So sometimes it's just hard to get all that information. I apologize. But what you're doing is the defense is learning, and what I think we're starting to see is lower verdicts.
Lower values, yeah. I mean, you have a smarter team, a more prepared team. They know what the argument's going to be. They know what the experts are going to say, and they're just prepared. It's very difficult because there's not a smoking gun to throw out there, right? I mean, so to your point, specifically, it's going to be more and more progressively difficult. And then you had, on top of that, compounding, you had 2 bankruptcies with the LTL and Johnson & Johnson, and then now you have this extra layer of complexity with Beasley Allan. And right. I can get into that for a moment unless you wanted to jump in.
Well, I was just going to bring up, that's how me and you started talking about it and going, wait, we need to do a podcast. This is crazy interesting. I thought, and it's hard because these articles, and that's why I wish we had more absolutely perfect information. Unfortunately, we can't, because of the way finding this information is not easy, and getting one of these lawyers on the phone and go, hey, what'd you get on? They don't want to talk about it anyways. And that's like what we learn in Lanier. It's like Fight Club, no one talks about it, that you go and use it in your trials, but you don't talk about it. That's one of the agreements you sign, confidentiality agreement, because they don't want the defense knowing what Mark's teaching us. And so from what I read, was one of the most recent verdicts was Not 4.4 billion that was reduced to 2.2 billion. What I saw was only 250,000.
And you have all these different, the people who suffer are the individual families, the communities, the people who were hurt, right? I mean,
Yeah.
you have not just claimant fatigue. I'm going to actually just speak very plainly. You have claimants passing away now. You have
Yeah.
claimants who cancer, and they might have had cancer for now 20 years because they filed so long ago, and this thing is going for so long that you're talking about people now passing away, and then their next of kin are involved in this lawsuit, and they're getting fatigued. You know, they have all these layers of, you know, helping out with mom's arrangements and everything that's happening, and then now just 2 years later, they're seeing this verdict that's such a small amount, and you know, potential settlement values that could be argued to be too low, and people are forgetting that, not you, right, but like
Right.
the greater scheme of things is
The
that
human
there's
side.
individual claimants that are really hurting.
And like I spoke about before, where the client's like, you know, I'll give you all the money back to give me my health back.
That's right.
And so for someone who you brought up, which is really important, and they passed away, they never got their chance in court. You know, because these cases take a long time, and they take a long time for a lot of reasons that, you know, it's just how the court procedure works, and it just takes time, and you got the same witnesses, and you're scheduling around other trials. But yeah, they never got their day in court. You know, and now the family's dealing with, you know, a death versus, you know, illness. But that's now where we get to the craziness.
Yeah,
we
there's
like
a
to
couple
call it.
layers here. There's a couple layers.
yeah.
I mean,
Yeah.
you have law school ethics professors, and this is part of the research I was doing, who they're actually filing briefs arguing that the disqualification I'm about to talk about is unprecedented and wrong. You have attorneys who are saying that it's actually the crime the punishment fits the crime, so to speak.
Right.
And so what actually happened? I mean, you had a situation where Beasley Allan, who I respect, fantastic attorneys in Beasley Allan, they got disqualified from the federal Talc multi-district litigation, the MDL, right? Because one of their partners was working with a former Johnson & Johnson attorney on settlement strategy. And this is all the conversation that was had. So I'm going to ask you, you know, from a criminal defense perspective, from a personal injury perspective, from a human lawyer perspective, you know, you deal with these things, conflict of interest rules, and, you know, who's at fault and who's negligent. Do you think that the punishment fits the crime to be fully disqualified? And what does that mean, as we were talking about, what does it mean for the claimants? Like, does it protect or hurt them?
Definitely hurts them, because now you got this added layer mess going on. I think one of the problems is we'll talk about how it got to that point, but
Yeah.
it's like Mark says, always simplify it for everybody, and we can either do it with a card, you're going to buy a car, or you're going to settle your car accident case. And so you have your lawyer that you hire to because you got injured in a car accident, and one of the partners goes over to State Farm after meeting with you or talking to you or working supposedly on your side, and then he goes to State Farm and says, hey, I know what, this is way exaggerated, but going, hey, I know, we've talked to them, we know what they'll accept. How are you going to feel as a plaintiff when that happens? You know,
Yeah.
how would you feel? Or the guy let's say, we'll make it simple in everyday terms. You know, they have people that'll say you're about to buy a car and they go, hey, let me teach you, or, you know, to how to negotiate the car deal, right? So you go and talk to him and he says, these are the things you want to do when you're negotiating to get the best deal on a car. Then you go down to the dealership, and standing behind or in the manager's, the sale manager who approves the sales is sitting there, and the salesman comes in and goes, this is what, you know, where we are in the deal. And the guy you talk to is sitting there, and he tells, I know what these people want, you know? So because it's complicated, but I mean, when you're talking about conflicts of interest in law cases, I can see why everybody's going, yeah, knock them off every case. You know, how do you have trust in the system and in your lawyer if they're playing both sides. You can't do that.
Yeah, you feel taken advantage of, or you feel like you don't have your opportunity, right? Your story's not really being told. You might
Or
feel like a
believed.
number.
Or
Yeah,
believed. Whose side are you on? I want someone who's fighting
right.
for me. I want someone who's in there
Yeah.
like Mark is, going all out, knowing as much as he can. I don't want somebody who's going to be going anything to do with Johnson & Johnson is the enemy. Why are you even talking to them?
And there's a whole lot of money being thrown at these law firms to finance the acquisition of these cases, the case workup of these cases. So not only is there money to potentially be earned, right, from successful resolution and a global settlement of these cases, or if it's a verdict, right, as long as it doesn't get appealed, you have the situation where you can make a lot of money representing your claimant and the person that was hurt and telling their story and having a good resolution. You also have economics that are thrown at this because the actual institutions, the financial institutions that are saying, hey, I believe you can do this. We want to help a lot of people. Let's lend you money because these are very expensive. Let's lend you money to acquire these cases. And then now you have this whole situation that has layered, like almost like an onion, peeling back the layers. I'm going a little bit, back and forth, but you have Allan Smith, you have Smith Law Firm, you have Beasley Allen, you have an alleged $240 million in loans that are potentially going around there. Allen said they never happened, and this goes back and forth. But in general, when you're trying to build your practice to win in this kind of talc situation, and now you have two partners that are supposed to be working together and they're suing each other, the claimants are stuck in the middle. How does that make the outlook of the lawsuit? Does it affect the MDL at all, or do you feel like this is an isolated thing to those firms?
No, I think it's going to reverberate all through. This is going to have so many far-reaching. This is going to be studied in law schools, I think, because well, you got states like Arizona, that's allowing non-lawyers to be part of law firms. You've got powerhouse law firms doing tons of marketing, and they go, hire us. We're the biggest. We're the best. Well, who's working on your case out of the biggest and best? We got more lawyers than anybody, but am I getting someone out of law school, or am I getting the top dog who's getting big verdicts? And so to explain it a little more, I'm going to go with my understanding on the news, and I might have some inaccuracies in here, but to kind of flesh it out a little more, is that in order to get these cases, there's a lot of competition. 3M, Camp Lejeune, I'm sure you've heard the advertisement. Everybody, I'm sick of hearing about Camp Lejeune. I'm sick about hearing this. But you can see $4.4 billion on 21 cases. That's a ton of money. And so everybody's like, wait, I want to get my hand in the box. Where's mine, right? On these big players, big money. So to get the cases, you have to advertise. You got to get social media, grassroots. You can do pay-per-click. The budgets are crazy. I remember one of the first times I went to Mass Torts, I met one of the marketers, and I go, how you getting the cases? And he goes, well, we do pay-per-click, we do social media, all the, grassroots. I go, well, what's like your budget on pay-per-click a month? And he goes, I don't know, 4 million. $4 million? But when you see the money, right? But when you see the money, you're like, holy cow. So hedge funds as lenders are helping to fund these, but at the same time, lawyers need the funding because the lawyer doesn't have 250 million or whatever it is to fund. It's expensive to litigate. And when you got to bring in your cancer expert, that's not cheap. When you got to do depositions, when you got to sit, I don't know if it was 6 weeks, the internet addiction trial is, you got to pack up, not make money, leave your family, go to LA and try that case, and you got to stay somewhere. You got to feed your staff. You got to have everybody there. It's expensive. And so we just take a second, take 1 second. I just want to make sure everybody understands, because we have a lot of personal injury lawyers, but also I have a lot of potential claimants and just people, civilians. And that's a topic that a lot of them don't know. So I'm going to take one beat and let you continue. These are on what's called contingency. And contingency fees, this is also a lot of what Tom works on, is we don't get paid unless you win.
unless you win your case. And so Tom's taking a bet on himself. You know, these firms taking a bet on themselves. They're coming out of pocket, and they are putting all these efforts out up front. And that's why they have to borrow money sometimes, because if you're staying at these hotels and you're feeding people and you're doing all these depositions and you're taking these things to trial, you have a tremendous amount of capital you have to put out there. And that's before you even get the cases, right? You have to get the cases too.
Well, here's the problem.
So these situations allow you to hire the best lawyers because of that.
Let me make it real simple for people. If it was you going up against Johnson & Johnson, do you think you or the lawyer you're hiring right down the street has enough money to fight a billion-dollar company? It's as simple as that. And so you need help. Sorry, but that was
you're right.
And that was
100%. And so that's the reason that a lot of people can hire these amazing lawyers, because it doesn't cost you more. It doesn't also cost you more if the lawyers team up. And so a lot of times it takes a village of all these different law firms working together, collaborating to fight against these billion-dollar entities where they are hiring very expensive lawyers and paying a lot of money to the tune of millions of dollars a lot of times just to litigate these cases. So you're going against this big conglomerate and you're hiring all these law firms that are going to represent you. These are the plaintiff law firms. These would be the good guys. That's Tom and Mark Lanier and Beasley, Allan, and Allan Smith. You know, they're trying to acquire enough cases, meaning meet enough people, represent enough people, so that they can make a difference in the litigation. And I think Allan had like 11,000 or something.
Yeah, that's what I was going to talk about. But yeah, that's the problem is, even with the village, you're fighting against Facebook, who's worth billions. And after the verdict, now it's not just because of the verdict. You got market factors, you got Iran going on, you got crude oil going up. But Facebook stock took a hit. And so they're going to fight you for everything they can, because 2% of how many billions they're worth or trillions, it's worth it for them to put in every dollar they can. And a lawyer on the corner, and as big as Mark or any Beasley Allan are, it's just a huge, you can't afford that on your own. And it's too much risk to say, I'm going to pour all my money into fighting this lawsuit. And that's why we have funding companies, which is good, but you got to be careful with them, because it's Allen White suing their funding company now, right?
Yeah, you have. I believe that was the conversation. You have Allan Smith with multiple funding companies. I won't name them, but basically going around this whole $240 million conversation, suing 3 or more lenders in Mississippi, accusing them, and I'll quote this part. This actually came from Legal Newswire, Legal Newsline. That's why I pulled it up real quick. Motivation was pure greed, realizing the billions of dollars at stake in the Talc litigation. And that's to the lenders and having predatory loans about this process. It's just one layer, on top of the Beasley Allan conversation.
So my understanding is that you're doing the funding, right? And Allan Smith is trying these cases, and they're going along. And it kind of works like a line of credit. Here's some money. We'll give you $30 million. Here's some money. Here's some money, because you need them for the experts. You need them to file. A lawsuit's like $1,000 to file. And you got to file those for all your clients. 300 clients, $300,000. You see how expensive it gets very quickly. So they get a funding company to help them. And Allan White, my understanding is, took over some cases from another attorney and said, we'll take on your cases. Sometimes they buy them. Sometimes it's co-counsel. There's different ways to acquire cases, because not every firm's going to litigate, or, it just makes economic sense, because you're being dragged. You're not just doing talc cases. You have other areas you're litigating. So they have a $30 million loan. Verdicts are not $4.4 billion every time, and now they're going down, and you get bad feelings too. But if it's only $250,000, a funding company might go, whoa, we're not going to get paid back. You're cut off. That's it. We're not giving you any more money. And like, well, no, we need the money, because in the one article it said that Allan White had 11,800 talc clients. That's an incredible amount. And so you have to litigate those, and your funding company says, we're not paying for the experts, we're not paying for you to file the lawsuits, the money you were counting on when you took these cases on, and you're in a world of hurt. That's why they're now suing the funding company, go, hey, we had a deal, give me the money so I can help these people. Then, I don't know if you want to start this one off, but then we had Texas two-step where Johnson & Johnson goes to Texas, spins some off, trying to declare bankruptcy, and if we're bankrupt, then I don't have to pay you for the car accident. I'm bankrupt, I declared bankruptcy, I discharge anything I owe to anybody. So that's how, on an individual, to get out of paying for a car accident case. Well, Johnson & Johnson's like, we'll go to Texas, we'll spin off Talc, and then we'll just declare it bankrupt, and we'll keep going as Johnson & Johnson, we won't pay these verdicts. And that's the Texas two-step that would stop, but it got to a settlement point, I believe, and this is where more bad feelings came in, because when one law firm says, because each person gets a vote, the lawyer votes for his clients and goes, I got 11,800 votes, I vote in favor or against the settlement offer, and then that one fell through, didn't settle. Then the firm that you took the cases or co-counseled said, hey, you should have voted the other way. Now you violated our agreement. We want our cases back because you're voting. We don't agree with how you're litigating. And now we got a huge mess. And that's why I say this is crazy. You were talking about 200.
Yeah, I mean, if I took out a series of loans and they're compounding, right? They're adding up every single year, and this is now, like I said, like a decade and a half. You have to appreciate that. It's a long time. And then you have an opportunity to get out, and you have a responsibility for your claimants, and there's going to be an argument there, right? The claimants need to have an amount that is substantial enough to satisfy being able to take care of the individual for their lives and be able to compensate them and their families for cancer, right? Like real traumatic, life-changing events could lead to ultimately, death, right? It's people who died because of your product. And then now this offer that came from bankruptcy court in different areas, and that it was born from that, a lot of law firms had, you know what? Let's get the individual claimants paid now. It may not be as much as we wanted, but we end it now. They get something. They can move on with their lives. They have some closure. They have the ability to actually get some finances back. The law firms can start paying back these loans that are compounding. And these are the conflicting conversations that happen. You have law firms that say, no, we're not going to agree to this. We're going to vote no. And you have law firms that are saying, hey, I want to agree to this because I think my claimants would like to get paid something now. Getting paid $1 today versus getting paid $1.20 in 8 more years may not be worth it for my claimants. And that started a war amongst the plaintiff bar. And unfortunately, you have business partners that work together. Like you said, co-counsel. They collaborated on originating individuals and finding the claimants. And then you have another law firm partner that maybe is handling a lot more of the settlement conversations and a lot more of the legal gymnastics in the end, right? So the whole life cycle of a claimant journey is being handled by 2 different law firms, and that's actually not uncommon. It's very common because it takes a team, like we said before. It takes a village. And now you have this big lawsuit where 2 law firms are suing each other.
And the funding company.
Right. Sue everybody.
Yeah.
And they're still suing Johnson & Johnson, by the way.
And that's like, I'll get people bring me in for certain cases. If somebody came to me and they said, I have a Talc case or one of these other mass torts that are going on, depending on what it is, I'm not taking it. I might bring the client in. I'll refer them. I could sign them up and refer them to somebody. But typically, from going to the seminars, I know, because I can't afford to do it for one. 2, I don't have the knowledge that Mark Lanier or, Allan Smith has, or Beasley Allan, because you've dedicated your life, you've paid the money to the experts that are teaching you, because they're the experts, obviously. And so for the guy on the corner to just say, okay, I'm going to take your Talc case, it's just not going to work that way. So you're in this. That's why I say this is crazy because of the money that law firms suing a law firm, suing funding companies. Where's the money? And the poor people are going, what's going to happen with my case? I didn't have enough problems.
Yes.
And now I'm like, what, who's my lawyer even? Which was a 3M thing, right?
Yeah.
And that was, do you know about 3M and what happened there?
I think. Go ahead.
All right, because this is why the mass tort thing is fascinating, and the arguments, and you're getting the best lawyers in the world, right? And so I also heard that in 3M, here's kind of the problem. You said it's been 10 years, right? And so as a lawyer, how often are you talking to your client and things move? It's a hurry up and wait. It's kind of moves at like a glacier, and it's moving slow, and then all of a sudden you get to trial, you whatever, and it's like boom, boom, you're running. It's like, now we got a deadline, we got to fly. And so the problem, this happened in the 3M with the earplugs with our military or anyone
Combat
who used
earplugs.
them. Yeah, that it, instead of deafening the sound, caused the sound to be amplified and deafen people. And we had our military shooting guns using these earplugs, and they're like, you made them deaf. You didn't prevent the death. And what happened was, because not every lawyer was doing town meetings or, keeping every month or what someone would expect, because some people think, oh, you're going to talk to me every day about my case. No, nobody's doing that. And, that's extremely rare. As you get closer to the event, you might do that. So these people would go see an advertisement or something on social media and go, I haven't heard from my lawyer in quite some time. He must have forgot about me. So they signed up with another lawyer. There were some people in 3M, and they had 9 lawyers. So then the judge got ticked off, the federal judge, and then they said, you guys, whatever way, I think it was, you guys fight over and figure out who's got the client.
Yeah.
Yeah, so there's a lot of money involved, and that's why I say, you think going to a timeshare sales is something? These guys are, they want their cases and they're fighting over them, and that's why they're trying to claw back their cases going, I would not have handled the case that way. And the question is, well, you gave them to us or we took them on, and where are the decision makers? And that's one of the problems you get with strategies. Like sometimes people go, I want you to work with this lawyer. And I'm like, I've never worked with him before. I don't know if I can, because his strategies, his arguments, his style might be different. And sometimes you want competing styles. But it's hard to work with someone where you're not in with them on a daily basis. You have the trust and you have the same philosophy on how to try cases. I'm a huge Lanier fan. I tell everybody, and they're like, you're just a fanboy or whatever. I love them all. Anyone who can teach me something, I'll take. But the way Lanier does things is not the way some other extremely good lawyers do it. Him and Papitonio, I think, are very different in how they do things. But Papitonio, he's a bad mother. I ain't gonna swear on this one on my podcast.
The legal circus, we will.
Yeah, legal circus, we can say that. But yeah, I mean, they're very different in how they approach things, but both are extremely good, great lawyers, but they're doing it different ways. And to put them in the same trial would not necessarily mesh well. You could do it if you had, okay, you're going to handle, which Mark doesn't really do. You're going to handle these witnesses, and I'm going to handle these witnesses because they need to be handled differently. And Mike Papitonio might be better for that witness with this style and Mark. But Mark's no pushover. Mark, if you watch the clips on there, and there's the one of him doing the cancer doctor out of Cornell, I think it's online on YouTube. Man, that's hilarious. That is just...
I think it's important.
He just destroyed them. And it started out with, let's go with the 7 forms of cancer. And he's like the director at Cornell or something. They flew him in for the trial like the day before. And then Mark on the stand just destroyed him. And he's like, this one, no, you already said it. No, how about this? And he goes, you mean this one, and said it wrong? Because just Mark had him so rattled. But Mark is a preacher, nicest person in the world. But man, in trial, you get to certain points where you've got to take care of the witness. This is one. Did you see, what was the one with Afro Man? Did you see the trial?
I did not watch it. No, I did not watch it. What did you like about it?
It was great. We got to do a podcast on that because that had
Yeah.
so much Afro man dressing up, and it's like you had to tell your clients how to dress. He dressed perfectly. He's like, "This is America," wrapping himself up in the flag because he wore the flag. He had the sunglasses, and at one point, the lawyer asked the plaintiff in that case, and I'm totally on Afro Man's side, and I'm glad Afro Man not only won, he kicked their butts, and
Yeah.
so at one point. I think it was his attorney who did a fantastic job. But this is something you learn in the academy. Why I tell everyone, go to Lanier Trial Academy, go to these seminars because you meet people like Mike, and then you got support staff, you got knowledge, he knows people you might need to meet. But at Lanier Trial Academy, they'll teach you how to do this the right way. But he asked the plaintiff a question, and the plaintiff gave an answer that the attorney did not like. So he turned to the judge and he said, "Judge, he didn't answer my question. Would you please direct him to answer the question?" And guess what the judge said to him?
What? What did the judge say?
He goes, "Counselor, he did answer your question. You just didn't like the answer." So the question was something along the lines of, do you know if your wife is actually sleeping with Afro Man? And it was like, well, you would have to go and ask her. And
Yeah.
it's a defamation lawsuit. So if you're saying you made a false statement, I slept with your wife, you need to know the answer, is no, he did not. And it's a lie. It defames me. But instead he said, well, you would have to ask my wife. And then you go, "Judge, would you tell him to answer the question?" And you look like a weakling in front of the jury. You got to be in control of the witness. It's your courtroom. You get in there and you go, "I own this. This is my house." And then you need to do that from the first thing that happens in that courtroom all the way through. And that's why Lanier, if you're not, doing what you're, trying to be difficult, he's going to make you look bad. And that's what, you learn it, you use it, and you're like, fantastic, but that's really important, and why Mark can be not always a nice guy if he doesn't have to be, we just got to.
Well, he's an advocate, right? He has to advocate for his client, and that's the duty that he swears, right? And when you become a lawyer, you have to make sure you do everything you can for your client, as long as it's legal and ethical and everything that you can do. And Mark is probably the Michael Jordan of trial attorneys, who
I wouldn't go.
He knows when to turn it on.
There's so many good ones, though. So many good.
There
ones.
really are. I mean, right now we have. I mean, you have Michael Watts. You have an incredible amount of lawyers that are just amazing trial lawyers. I mean, Justin Nelson over Sussman Godfrey. If he wins one more, $100 million, $1 billion verdicts, tens of billions, $100 billion, and he's one of the more decorated lawyers. There's plenty of people out there.
That's
and
like
then
drives me crazy. I'm like, when people say, I go to the seminar, or they go. I went out with this girl and she goes, "You go to the seminar and that's all you do is party and get drunk." I'm like, "No, we're there learning and we're networking," because you learn so much from the conversations we've had where we're just sitting around while we're on breaks or after. It's like you just learn in a tremendous amount, because you can't see anything. Like just Afro Man, you didn't see it. And I won't say it on here because it's one of the things I save for my friends and for people. Next time or after we're hung up, I'll tell you what you could have done with that witness. And there's a lot of different ways. What question did I ask you? What question did you answer?
Yeah.
Are you done with that? Would you mind answering my question? But there's an even better way, but I don't want to do it on here because it came from Mark, and it's the one I use more than anything, and it's just... It's killing.
Well,
the first time I did it, and I surprised the clerk with it because they're in the court with us, and then she just snorted out laughing, and it could. Judge looking over at her. Judge, I think, was trying not to laugh, and that witness was just done, done when you do it the right way. But you're not going to know it unless you go to the seminar and you learn from the best. I'm not afraid to say it that I can learn a ton from Mark, and I couldn't do a Talc case. It's, but I find this interesting that this money that's going on that you never knew about, and that's like most of the public doesn't understand. And so when there's $4.4 billion that's getting split up on 21 cases and you got 11,800, the potential money is crazy. And that's why everybody's fighting over this. And the problem is you got as you were saying, you got competing interests. You go, I want to help my client, but do they need help today? Are they in for a fight for the rest of their life where they don't care about the money, that they're like, I'm at the end, I don't care, I want them to suffer, I want that big verdict. And as a lawyer, you know, you get to a point where you're like, you know, are the verdicts going down, or how much can I pour myself into this time and time again, doing the same trial over and over and over? You know,
Yeah.
you get a little.
Sorry,
Go ahead.
I was gonna say, you know, so what is your feeling now? Do you feel that individuals should try and settle, or do you feel that the fight is still? Do you feel like there's still a fight ahead of us?
I think there's a fight. I don't think Johnson wants to settle, and then you got to get
Yeah.
it through the judge anyways. And you got so many people and that's part of the problem with the mass torts, is you got so many people with different feelings on how they want the case to end up. And so that's what makes this the crazy world of mass torts. You know, it's, you got crazy money, you got strong personalities, you've got people who have suffered and have their own agenda, rightfully so, and they're all competing kind of in a way. The goal is the same, but how do you get there, and what is the ultimate goal when it's, you know, is it dollar amount or is it your day in court? And that's the problem you have. And so it's a tough decision. And I think it's going to be one of the most educational things to come out, because you better watch out what you're doing and who you're doing it with. You know, you got to trust your lender. You got to trust your co-counsel. You got to make sure it's cases you can win, you know, and that's like Mark, like I said, that's why it was important to give you the background to go, I don't want these cases. You cannot win them. And then it turned into, okay, we got the scientist that says, here it is, smoking gun type of stuff. And they won it. And Mark still, I know, taken some of those cases because of someone I spoke to there yesterday. And, but, you know, where it's going to go, I don't know. I think it's fascinating. But I don't think anybody knows the money and what's going on here when you're the public and you're like, what?
It's an interesting area, especially when it comes to new claimants. Because the thing is, people are still being hurt from it, right? I mean, even if baby powder is off the shelves, the damage is done for a lot of individuals, and so you also need to earmark some money for future lawsuits.
Right. Yeah.
That's another portion of this, and when it comes to claimant acquisition on my end, right? So for the marketing area, you need to make sure that you don't have that dual representation that you were talking about with 3M combat earplugs. Is, you know, do you have an attorney? Have you signed anything? Because they hopefully have been speaking with the firm at least in updates, but a lot of these firms don't give updates, and you either forget or the claimant passed away and now you have different people who don't even know if they have a lawsuit or whatever. Here's these different issues come out.
Here's one. Yeah. Who's your lawyer?
Yeah.
Like, if you're going on, you know, you guys market them and are getting them. If you're going on social media or you see those mesothelioma commercials they used to have, I didn't know who that guy was. And then is it staying with them? Is it going to someone else? Or am I talking to a marketer? Am I talking to a lawyer? Who's your lawyer type of thing, you know? That's why doing the podcast, letting people know, going, look, it's a crazy, they don't teach us this in law school. You learn by going to seminars, getting into that area of the law. And from doing them, part of the reason, if someone comes to me because they know me and I'm, you know, locally, and they come to me and go, hey, I have this issue, I trust you to point me in the right direction to a lawyer that can help me with it. And that's another thing. Just because it's a Talc case, that doesn't mean that Papatonio's taking it, doesn't mean that Bell and Southgate. Certain lawyers only take certain ones because they believe in them. And when they take these cases, it's the same thing as investing in a business. Do I think that I'm going to open up a shoe store and I'm going to make my own shoes and I'm going to compete with Nike and everybody else? Well, you're not going to make any money on it. It's not a good business idea. And so what you're going to end up doing is going, I'm going to open a restaurant instead. Tough business, but you're going to choose a viable business. Same thing with lawsuits and mass torts. A lawyer decides, is this viable or not? and it changes over time. This is crazy.
Yeah.
I saw it on YouTube, another podcast. This is crazy. In the 1990s, guess who bought CVS, the pharmacy store? And again, I'm going off someone else's podcast, but I believe they're very thorough. It's one I watch on a regular basis.
Well, I know right now it's Aetna and CVS, right? So
I think so, but
yeah.
in the 90s when CVS was still public, or still private, they got bought. Tom McCann's shoes, because Tom McCann was competing with Nike with shoes made in China. Couldn't compete because they're made, and their whole thing is durability and made here. America culturally changed and wanted cheaper, and will replace them in higher fashion. But as part of his branching out in retail, he said, well, this is a dying business. We need to get into diversifying our retail. He bought CVS, and they ended up bankrupting Tom McCann and just going, we're CVS now. And then from there it changed. That's the same thing with these lawsuits, is that as you're going along, Mark Lanier got $4.4 billion, but we haven't heard a $1 billion verdict, or else, we'd all know about it. Haven't heard one. Defense gets better, or jury's going down, down, down. Then you get to a point where you're going, look, I can't afford to take your case and keep it going. You're not going to get anything. You're going to lose in court. So you're better off settling sometimes.
Yeah.
And that's why it's complicated.
Yeah, I mean that's the, like you said, it's the mass tort world. You also see these $1 billion verdicts, and you go, oh well, I must be getting $3 million, $4 million because you're doing some calculus in your head about how it's a fraction of it, but it's really very different. I mean, we're talking about hundreds of thousands versus millions versus billions. And so it's setting the right expectations for the people that you're serving, right? These claimants, and making sure they understand, like you said, like, look, this has to be a situation that the defendant can actually afford. It's going to hit their pockets as much as possible to ensure that they, make change, and they don't put anyone else in harm's way, and they're also held accountable for these issues. But at the same time, realistically, if we're talking, tens of thousands, if not hundreds of thousands of potential plaintiffs out there, you can't pay every one of them $3 billion.
Right.
And so it has to be a realistic situation where you go, hey, look, this is where we're going to end up. And that's the argument. That's the nexus of the argument of, whether or not you take a settlement offer that is deemed to be too low, too high, or whatever.
If you have one firm with 11,800 cases, there's a lot of cases pending out there. And how good or bad is your individual case versus someone else? Here's another big thing and that's why it's complicating and it's fascinating. You just brought up the 100,000, and then something you said, I don't remember what it was, but it was huge. And again, it's why we have to tell the whole story. And I find it all incredibly interesting. And that's why I love talking to you about anything law. Love it. Is you needed to know how the cases came about and how they went. And you needed to know that in order to understand this, that Mark Lanier got $4.4 billion, goes to San Francisco. You cannot do his argument. So is your case that you have those dollars and you're going, well, that guy got 4.4, 21 people, and they got a big cut, so I expect a big cut. But that was in St. Louis. What does a St. Louis juror give you in front of a judge that was fantastic? He was a NASCAR judge. And what that means is that he let the lawyers go at it and he gave them a lot of freedom. But you can be in front of a conservative judge who's like, I'm going to do everything I can because of their mindset, that I'm going to do everything I can to help Johnson & Johnson. And they might, cut a verdict down. They might, make it so that you just can't win. And so those are factors that for 100,000 people, it gets complicated, and you get to a point where you're like, there's only so much money to go around. There's only so much time and effort you can put into this. And, that's why I think it's just fascinating. And that's why I think it'll be studied in law schools, even though they typically do not talk about this area of mass torts and what you're looking at. It's unbelievable.
Yeah, and venue is one of the more important areas when you're underwriting a mass tort, whether or not you want to get into it, right? So you have the financial viability. Is defendant liquid? Are you going to have a situation where you can actually, win? Is there meat on the bone type deal? And then also, do the injuries, does the adverse event match any sort of profile that actually will help. You have the scientific viability. Like, is it going to pass Daubert? Is the science going to have a positive correlation? Like you said, is the jury going to say this caused that? And then you have, situation with plaintiff numerosity. Are there enough people who were hurt and impacted? And you go down the line of all different areas of underwriting the mass tort and figuring out whether or not it's a project that you can actually work on and afford to work on without overextending capital. Venue is up there as one of the most important things, because if you are in an area where you're not going to have a judge that potentially gives a fair trial, or the jury itself is going to have some sort of bias somehow, and you think about like a Kodak moment.
You're trying it in Johnson & Johnson's corporate headquarters city, right?
Right. And the jury, they all know people who work there, right? Yeah. And so it's a situation that is just fascinating, and I love it. I love this whole industry.
Right. And then the other thing is, it depends on your jurisdiction. In Florida, and federal's worse. In Florida, you get jury selection. You get to pick who you want, and we have one of the better ones. We've got we got to do a podcast on this one, on the jury selection that just came up. Maybe we'll do it at the end, and we'll add on one for us to do, because this one fascinates me. But the jury, if they can basically say, I can be fair and impartial, despite the fact that my grandfather worked at Johnson & Johnson, my father worked at Johnson & Johnson, they bequeathed me with $50 million worth of their stock, which I still own, but I can be fair and impartial in this case, and a judge lets them on there, what's your verdict going to be? It's an extreme example. You're getting zero because he doesn't want his stock price, his pocket affected by you. And so, to simplify it, it's like, I use a lot of DUIs because DUIs are easy for people to understand. And anytime you had a DUI trial, someone would go, the client always goes, are we going to win? What's our percent chances? And I'm like, there are no percent chances, because every case is different, and I don't know who's going to be on your jury. And if somebody who had their whole family that was tragically killed by a drunk driver, and they say, I can be fair and impartial, and there's 3 of them on there, or 4 on there, and you got 3 peremptories, and they say the magic words to get them on there, they're going to be on your jury, and you're going to lose. In all likelihood, you're going to lose, because their experiences and their personal biases come into it. That's why every trial is a risk, and there's no guarantee of $4.4 billion. And that's, hey, I got 11,800 of these cases, and I'm going to get rich, and I'm going to be, a hero to everybody and make this money. But you better be careful, because are you going to win them all? And do you have the money and the time and effort? It takes a lot to try cases, and these are not short cases. They're long.
Yeah, absolutely. I mean, it's a war, because they have to, again, when I say they, the defendants have to protect their investors more often than not, and they have to make a predictable outcome that is going to not scare the market, and they have a lot of different layers for them to protect. So it's a very difficult, it's a very difficult battle that happens.
Well, here's another thing you bring up, is that if you have 11,800 clients, right, and you got 11,800 trials that you're going to do, and it's going to be you, and Johnson & Johnson has, let's say, one law firm, we'll even say, but it has 500 lawyers, and they've studied the playbook, they know what's coming. So can you substitute in another defense lawyer to go, okay, we're going to let you do this trial? For whatever reason, they can pick it, right? Because you know who the plaintiff is, you know who has better damages, and they go, all right, we're going to let this attorney do it here, and maybe they're a newer associate, but they have different lawyers that they can choose from. You got one lawyer trying case after case after case, and he might know it better than anybody because he's doing case after case after case. But as a trial attorney, it's draining to try case after case after case.
I was talking with Kelsey Stokes, one of the most phenomenal trial lawyers I know, who just joined the Lanier Law. I mean, she was fighting hernia mesh forever and different things, and she was up there pregnant. I think she was like 8 or 9 months pregnant in the trial, in the courtroom, and fighting against all these huge corporations and entities. It's just, I mean, I have nothing but respect, and that's what I love about you as well, is that you're realistic about things, and you talk about what it's like in the life of these attorneys, both on both sides, and the claimants. It's, you have a perspective that's just refreshing to hear, because you don't sugarcoat or pretend to, you tell the real story.
But that's the problem, is you got competing interest of everybody. No matter what, that's human nature, that the lawyer versus the plaintiff, it's still there a little bit as to, what's the best way to go. But yeah, that's it's fascinating, It's just incredible. Everything about this. And that's what it's for us to prep for this. We spent this whole week going back and forth, trading news articles, trying to get to what are the meat of the issues and to break it down so you can understand it. And I don't know what time we're at on this. What are we at? An hour and 15 minutes, and it's like just fascinating that here it is. A law firm markets, takes over another firm. I got 11,800. Wait, verdicts are going down. The funding company doesn't want to give me any money. Now I got to sue the funding company. Now the firm that I was with is like, you ain't doing good enough. We want them back. I'm suing you. Well, I'm suing them. And then you got 11,800 people going, well, what's happening with us? But it affects, and that's why they had to be disqualified. Now that it come to it and you talk things through, is that how can you vote on settlements if we don't know who has these cases? And I think that might have been a big part of it, why they go, you're out, it won to go and talk to anybody on the other side. That's just, it's, whatchamacallit, who's the
conflict of interest, right?
Yeah,
Inside
Benedict
trade.
Arnold. That's Benedict Arnold, And then here's another thing that you learn in Lanier Trial Academy. You don't stereotype people and everything, but you use those shortcuts. So if I said Benedict Arnold, you understand what I'm talking about. And I don't have to go through all the betrayal of how bad you felt and what they did. I just go, he's a Benedict Arnold. And you get what I'm saying. It's like, that's what trial is. And there's people, I'm not afraid to admit it, that are way better than me. So I'll go learn from them. But that's what it comes down to. And that's why a lot of times you're not sugarcoating. It's like, it's what he is, like the jukebox expert, that type of stuff.
So look, I mean, we were talking about how, you had some inside kind of tips from Mark that has helped you in your trials and everything. So if people wanted to get in touch with you, it's Grajek Law or getgrajek.com, right?
Right. Yeah. Here in Florida. So, and if it's not something I can do, or, you can always call me and I'll put you in touch with the right person, right area, and same with you, that so many lawyers, a lot of lawyers I don't know in those mass tort firms and everything, that, going, hey, Mike, who's handling these cases? So you can get to somebody who knows whether you have a case, whether you can trust them, whether they're going to do, a good job, because you don't want to be in this mess. This is crazy.
And we'll both be, are you going to be at MTMP?
I don't know yet. I haven't signed up for it. My friend keeps
Lanier,
asking.
definitely.
Yeah, Lanier, I'm signed up for. I've got to do one on, I was at NTL speaking, and I've got to speak at one here for the Florida Bar in May, so I know I have that one. The problem is, because of my trial schedule, and we had one going that we were at mandatory docketing yesterday, and there was witnesses unavailable, I got kicked, and that's the problem. And that's what, as a trial attorney, you don't understand. In federal court, they go, I don't care if you're in Japan on vacation or in the Bermuda, you're coming back and trying this case on Monday, and you better book a flight and get back. In state court, you got a little more leeway, but the week that you kind of block off for trial are these 2 days, and you're going to be in trial for 2 days, 3, whatever, the week, you can block it off. But then when it goes and says, no, you got continued and you got to come back next month, I'm blocking off a week. So I don't know if I can make it based on what I got going on. That's part of the problem, is you're just litigating so much that your schedule's taken over by litigation, and you don't get, the judge tells you, you're going to be here, you won't be there,
So we'll end on this last question for you, because I know we can talk forever, but I want to be respectful to time and everything, because you have things to do and people to help out. And I'm just curious, because you have so many passions about law and different things. What would be your final thought in terms of what you've learned from this lawsuit and your evaluation of this lawsuit that it can be applied to anyone who might be a lawyer in any discipline? Like, what did you learn from this that actually stuck with you the most?
I'm trying to think what it would be. And it'd probably be us going back and forth trying to figure it out. Because I knew the money was crazy, and I knew the funding part, I didn't always have no one ever gave you firm answers as to how it works, and I still don't know how it works. But I mean, I think the big thing is, I'll say this. I think this is the lesson to be learned is don't bite off more than you can chew. Because that happens in everything across the board. I get asked to help out a lot of other lawyers, and I don't think people understand how much, because you want to be the best, you want to win. That's why I do it. It's like you played sports. This is our sports. Why does Tiger Woods keep playing golf? Why do they keep playing? Don't they have enough money? And it's because you want to win. It's the competition. It's helping people. All that goes into it. But and it happens constantly, and it hurts clients, and it can cost a law license. Don't bite off more than you can chew, because I helped somebody with a trial. It was a few months ago, and it's a friend of mine, and I love her to death, and it's who she is, and I understand it, and I don't have a problem with it, but she likes to wear black. And I said, well, you're not wearing that in our trial. And it was her trial. I was just coming in to kind of second chair, and I kind of ended up doing it, most of it. But there was a reason why we did it that way and why I was doing most, because it was, like I said, you might want to have two lawyers, because we did, and we said, I'm going to be the guy who goes in, and I'm going to attack. You're going to do the closing, because I wanted it that way so that you have a different pitch, and it's going to just mesh perfectly. But I said, excuse me, no way in hell you're wearing that black outfit you wear all the time. She's like, what do you mean? I like this. And I go, no, because blue and gray are your trust colors. And so you're wearing blue or gray. She wore a blue one, and the impact it made to me, just seeing the stark contrast was just amazing. And the effect it has on it, again, stereotype, shortcut, why are you doing it? But that was somebody who said, wait, I don't really know everything I need to know about this case, and wasn't afraid to come and ask for help. So be careful what you take on, and that you're either going to put in so much effort to learn it, which is difficult because sometimes it's just experience is what learns it. Like I had a law professor, and he told me, I got so many scars on my back because every time I did something stupid, I got a scar on the back. I ain't doing that again. But I think that's the biggest thing. You better know the case. You better have an exit strategy, and that's all comes back to biting off more than you can chew. And so just to go finish it up, when I say the black, what do you associate black with?
So you're talking psychological color theory.
Yeah.
I love this topic. So black, you could go with red and aggression, or is it something different? Black
is funeral, right? Black hearse, black dress, black. We ain't going to my client's funeral, so you ain't wearing black. Yeah. You're wearing blue and gray. We're going with trust, You go to the studies, and you go to, he was the FBI agent who wrote the one book, fantastic book, and then talked to Romano, another tremendous lawyer, Romano. He's like, where's the scientific proof that says it's true? And I'm like, well, I don't know that there's really scientific. Well, that one there actually is on that one. But anytime you tell John and he goes, well, I've been doing this psychology or think this psychology works, John's always like, where's the proof? Because I want to know that it actually works and it wasn't something else, But that's they did the study where the person comes in the room wearing a brown suit, and he goes, oh, excuse me, I'm in the wrong room, and he leaves. And then next person comes in wearing a blue suit, and then he walks out and he goes, oh, or excuse me, I'm in the wrong room, and he leaves. And then they have the class, and they say, rate who is more trustworthy or more intelligent. And it was statistically significant that it was the guy in the blue suit.
Interesting.
What do you associate brown with? And then you can put up a poop emoji. right?
Poop or earth. Yep, greens and
Yeah,
browns are very
but
earth
that blue
tones.
is your. That's why I'm wearing this. I got blue, and the red is for look at me type of thing on this, and that's why I got the
Yeah,
flag and why Afroman had it on. It all matters in your trial. That's why every little thing you do matters, and so that's why I say when you say, don't bite off more than you can chew, because you might not know what matters.
I love
I
that.
think
I
that's the
love that
biggest
about
thing.
you. You're
What's
you're
that?
you're just a wealth of
Useless
information.
information for everybody, or
No, it's important. I mean, it's so good. And then people who want to have a fun exercise start looking up personal injury law firm websites and see the common colors, and then look up family law websites and see those common colors.
yeah.
The actual psychology of color theory is very real. I actually didn't know what black would have stood for, but that was you made it very obvious at the end. It's death. It's funeral.
Yeah.
It's gloomy, right?
Right.
Even if it's subconscious. And so these are some of the things that Mark talks about in terms of psychology, and you have deployed in your personal career and have done very well. And for individuals who want to get some more of this insight, whether you're a lawyer or not, Tom is one of the best people to possibly ask. I mean, he's studied this. He's a
That's
student
why
of
I'm
it.
plugging. I'm going to plug my Legal Circus podcast, which we're
Yes,
going to take this and steal it, and we're going to put it on both.
please.
But we did the one on jury selection, and so it was like, what's your favorite color? What's your favorite movie? What's your favorite dinner? What's your favorite holiday? And what's your favorite dog you ever had? So go ahead. Go ahead and tell me.
Want me to do mine? Yeah, sure. My favorite color is red. My favorite movie is Rocky. I forgot.
You don't remember what the third one was?
Yeah,
And,
I
and
remember dog.
right, but that dog was fifth, right? And
Yeah,
so in a DUI trial, the purpose of that question is so that later on in the trial, and this is what you learn at Linear Trial Academy, later on in the trial when the officer gives Tiger Woods instructions, he didn't do these, he did alternative exercises, whole nother story. But if you did the walk and turn exercise, it takes 1.5 minutes for an officer to explain that with, I think it's 15 instructions they have to give you. Put your left foot on the line, right foot in the front of it. Please don't move until I tell you to begin. And you go through, it takes 1.5 minutes. And so what you want to do is go, remember in jury selection when I quizzed you and you were wrong and dumb? Well, how can you expect my client to remember all those instructions when you yourself couldn't do it? Because he's as dumb as you. And it's like, Jesus, one, because you don't know that. That's why you use a roadmap to tell them this is where each witness is going, how long it's going to last. But you're going, hey, I didn't come here as a jury going, well, one, I didn't come here to take a quiz. Two, I don't want to look stupid in front of everybody. So I don't like you. And so I already made my decision in this case. And then when you tell me 2 hours later, I don't really care about that. You're like, yeah, that's why I made you look dumb and feel small and stupid and everything. Jury selection's about feeling warm. We do that. I explained that on the podcast, but that's what people do because they don't go to seminars. They don't learn.
yeah.
Shoot, Lisa Blue's there. And every time I'm there, I go, Lisa, I got a trial coming up. What do you think? And one time I told her, this is how I do jury selection. And it was like, is this case right for you? So if you had, you're trying to tell the juror it's really not fair. If you're on a Johnson Talc case and their grandfather worked at Johnson, their father, and now you own the stock, and they're going, I want to be on this trial. They're doing everything they can. So you have to learn and know how to get them off. And the way I would explain it is, I would go, oh, I hate telemarketers because they call me all the time. I'm running a business and it messes up my Google searches. And so if I was on a jury where someone was suing a telemarketer, I would just keep writing zeros and give them the plaintiff as much money as they want. And it's funny, right? And they laugh and everything.
Yeah.
And I go, so I could never be fair in a case like that to show an example to the jury how I'm like them, and because of my biases and experiences, I cannot be fair. So you laughed at it. It's kind of funny, right? Did you like that example?
I did actually. Do you have a? Do
I
you
thought
have
it was
a
good.
trap?
And I told
Okay.
Lisa Blue, and Lisa Blue goes, God, no, what are you doing? That's totally
She
wrong.
hated it.
Don't do it that way. And I'm like, what? It works. I don't know. And she goes, oh my God. And then she told me how to do it. I went in,
Okay.
it just by pure luck, next trial it came up. And I used it. It's a total flip, 100% opposite of what I did. And that changed the mood in that jury room that was, or in voir dire, in the courtroom, like you wouldn't believe. It was phenomenal. And I never would have known if I didn't go to the seminar and I didn't like become, I don't know, well, sometimes she remembers who I am, sometimes she doesn't. But for Lisa Blue, and I bug her, and she's so nice, and to be able to go, here's the answer, and here's how you do it. And she's working on Mark's cases, and they're going over word choice. Word choice matters so much,
Yeah.
you know, and witnesses, voir dire, everything you do. Yeah, we're getting way off topic, huh?
No, I mean that's the fun of it, right? That's
Yeah.
the thing. And I wanted people to fall in love with you, know
And
what you're
you.
about.
There you go.
You know, there's a whole lot of respect I have for you, so I appreciate you being on. I know that we both had a time coming up, so we can have another one. We'll do
Yep.
another podcast where we continue about the legal circus and everything that's involved with it and
That's
how
why
you can move forward.
the best thing is if people who comment and say, hey, how do you do this? Or what's going on with this case? How would you handle this in court? That's what's great, that with this platform, people can ask us, and then how does funding
Yeah.
work? How does marketing work? You know, what exactly, we got to do that more with you and say, what exactly are you doing? You know, some of the more interesting things that
Yeah,
people don't know.
absolutely.
Yeah.
Absolutely. And then the best way to get in touch with you, so was through your website or LinkedIn or you're
Yeah, I
you're
mean,
on different
everybody,
platforms. You're on Instagram. You're on everything, right? TikTok.
yeah, we lost our video person, then we got one that we're testing out. And so, you know, we need a video person that or a social media person that loves doing it and loves posting it because I don't have time. Just because we're an hour and a half, and then you're reading a lot of articles. I'm doing it anyways, and then we're going
Yeah.
back and forth before we get on here so that we had, you know, it was open ended. But what are we going to do? Where's it going to end up to explain this? But yeah, you can get me at Get Greyjack. You can call the office. You know, everybody has my cell phone, which I'd give out, but it's probably a bad thing. But yeah, I'm easy to find. It's Grajek. Everyone's putting the extra letter. But I'm easy to find, just like you are too, because I love your
Perfect.
TikToks.
Thank you. Thank you. I love doing it. I mean, I will say, if not for anything else, you follow Tom just because it's educational, entertaining all at once, especially for a lawyer who is covering topics that people are like, well, you know, why would I follow a law firm? He's going to talk about legal theories and talk about different things. Tom is making everything relevant at all levels. So you can actually enjoy his content, whether you're off the streets, don't know anything about law, or you are in law school, or you're a seasoned vet.
Yeah, and that's and it goes back to kind of Lanier's philosophy: is make it fun, make it entertaining, make
Yeah.
it remember where you remember. You know.
So
But yeah, that's a great part of it. And the best part is when people say, hey, wait, how would you do this? Or tell me your thoughts on that. Because then it's, you know what the people want, you know.
well,
But that's what's great
everyone
about yours
comment.
is- what's that?
I said, everyone comment what you love and what you want to hear next.
Yeah, and that's great.
go ahead,
They can
yeah.
ask you, too, is that if I'm not the person that has the answers they need, that you know someone who does. Or I do, too. But, I mean,
Or we'll
you would
find
know-
somebody.
Right, right. So
Yeah.
that, I'm not always the one that's going to have the best information for you. And I'm not, I'll tell you, I don't have any kind of ego and stuff. I'm like, well, I do, but I mean, like, you ain't hurting my feelings. And I'm happy to tell you I don't know, because that's right. Yes, no, and I don't know. Those are the three answers for a witness. And so I'm happy to go, I don't know. I don't have all the answers. So.
Well, the best lawyer answer is always, it depends.
No,
really
because
good.
then you're opening yourself and everything. So what does it depend on? Does it depend on whether your wife's mad at you? Does it matter, and you're opening it up. You don't want to do that with a trial lawyer. That's why it's yes, no, and I don't know. That's why
Amazing.
you're on the depends on when the lawyer's answering a client going, are we going to win? It goes, it depends.
All right. Well, Tom, look, I love you, man. Thank you for
I love you
joining.
too.
Thank you everybody for watching. And follow Tom. He's the best.
And keep watching Mike.
Thank you. Take care, guys.